designing technologies that preserve privacy and identity, and what is needed to develop them. So also talking about technology, but sort of what regulatory frameworks might overlay on those, how those guide the different types of technologies and choices. So take it away.
All right, so I'm really going to focus as much as possible on the technical side and not on the regulatory side. We know that technology and regulation are complementary, but this talk's really going to focus on the technology and not so much how specific pieces of technology work, but what's the process for finding, trying out, and then eventually deploying new protection technologies. So I do want a whiteboard, yes. Yes, I can't think without a whiteboard anyway. Okay. So this gives me a quick chance to say, why is all this stuff important? The reason that I think that this user data protection technology is important is this is my Android phone. When I go to a shopping mall and get on the mall network, what's the first thing Google offers me? Google says, hey, do you want to get on a VPN to protect your data? Why? Because that mall network is valuable data about which stores I'm near, what I might be shopping for. Google does not want to give up any data on me as an Android user to any of the small fry ad tech companies that are dealing with those mall networks. Anyone notice how Amazon stopped putting the names of the products you ordered in your email receipt? Why was this? Because Yahoo was parsing those emails in order to target people with ads. Amazon realized, hey, we've got user data. We're not going to let Yahoo have it. Google, I already said Google. Facebook kicked all the third-party DMPs off of Facebook. Facebook limits the extent to which they allow their data to be shared out to other companies. The one segment that doesn't do this kind of protection is the publishers. And for a variety of reasons, this is extremely difficult to do at the publisher-by-publisher level. Everybody fears messing with their CMS. So the protection on the publisher side is most productive, most effective to handle when it comes from the web browser, from the client side. So some of the approaches that browsers have tried and tested and made available as configuration options for privacy are content blocking, cookie and other state restrictions, double keying, where if a third party sets a cookie on site A, that same third party sees a completely different copy of that cookie on site B. And anti-fingerprinting. There used to be a feature in JavaScript called Battery Status API, where you could say, hey, how much battery does this user have left, as a way of deciding how big of annoying an animation you want to run. Battery Status API was primarily used for fingerprinting people, so they took it out. So if you dig into the stacks of configuration options that are present in a modern browser like Firefox, you'll see dozens or hundreds of these kind of configuration items. Of course, not all of them are coming out in browsers that are being shipped to users, and it's hard to keep track of which ones are at what state of development. There were some interesting questions about, quote, tracking protection in Firefox, because the thing that used to be called tracking protection is this, and the thing that's now called enhanced tracking protection is this. So it's hard to keep track of, but I can give you a little bit of information on the process that's used to decide what gets tested, what goes out. It's all run through a user experience research filter. And there's all kinds of user research that goes into this. There's one-on-one user research. There's studies that we do in cooperation with academia. And finally, there are studies that can be tested and randomly pushed out to large numbers of Firefox users. And that's called a shield study. So the tracking protection progress in Firefox right now is moving forward based on having gone through a bunch of these and then push them through that research process. So one of the challenges is to try to integrate publisher testing with privacy features that are coming along and make it so that the new version of a publisher web project doesn't break with the new release of what's coming in Firefox. And there's a release of Firefox called Firefox Nightly. That's essentially the best guess as to what's going to be in Firefox 2 releases out, as in one after what's in beta right now. And so there are things that will make it into Nightly for a while. People try them out, and Firefox ends up backing off on that. There are things that go into Nightly and then into beta and then into release. So the so far, we've been thinking about blocking all the bad stuff. And that's an area where browsers have been kind of playing catch up, because there's been the problem of enabling people to be tracked from one site to another that they really don't want to be tracked to. The next step is, how do we use the same process, the same system of coming up with good ideas, testing those good ideas, and then deploying them? How do we apply this to permitting sharing of data that the user has made meaningful, has given meaningful permission to be shared? And Peter, do you think you could talk a little bit about Storage Access API? I think Storage Access API is a really important, it's kind of a JavaScript nerd thing right now, but it's a key decision that you have to make in order to handle user data cross-domain.
I just have a few notes here in case I want to reference some details. So for those that weren't here yesterday, my name is Peter Delansky. I'm product lead for privacy security on Firefox. And so, as Don said, we go through this process, and it is based entirely on user expectations and norms of what they expect to happen with their data. And that's not always easy to get to the answer of, but it's very clear to us that the pendulum, to use Richard's analogy from yesterday, has swung so far in one direction that it needs resetting back in the other direction. And that is why, if you've seen some of our blog posts on this topic, we have a number that you can look at, changes to our anti-tracking approach and that sort of thing. We are moving to a default protection state for our users to protect them against a bunch of the third-party tracking that's happening unbeknownst to them. And so that will be coming later this year. You can see our blog post on that. There'll be more blog posts coming out in the weeks to come, actually, on this, around some of the policies that drive this. But to Don's point, this gets you to a point where, okay, if the third-party tracking or the third-party resources that are embedded in pages are blocked by default, in a consent-based world, how do you actually enable those if a user so chooses? And so this is where Safari and Firefox are implementing the Storage Access API. The Storage Access API is meant for the situation where you have cross-origin resources embedded in a third-party context, whereby those third-party resources don't have access to cookies or storage that a first party would have access to. And so the idea is with the Storage Access API, access to those cookies and storage by the third party can be requested, and then the user has to actually provide permission. This is hard because a lot of times the user doesn't understand the specifics around some of this, but the idea is that there would be a trigger. For example, a user clicks on the Facebook like button, or they engage with a comment system, or whatever it is on that page. That user trigger would invoke a permission prompt, and then the browser would say, are you okay with this domain, this third party having access to this data? And then the user basically can say at that point yes or no. And then there's various heuristics around it. I won't go into all the details here, and we have actually a bunch of documentation on this if you're interested. But the Storage Access API is the mechanism through which us on the Firefox side and Safari are going to enable users to say, yes, I'm okay with this sort of access. So I'll just want to kind of describe that at a high level. I won't go into any technical specifics here, but if you're interested, you can follow up with me, or certainly just search for Storage Access API. You'll find a lot of technical and other documentation on it.
But is this set up to be like, oh, sorry.
Yeah, go ahead.
Like 5 times on one journey into a site, I'm going to be asked and asked and asked and asked and asked?
No. So there's a number of heuristics there. So what we don't want is we don't want a user showing up on a site, and then we don't want the third-party resources on the site all being able to ask directly, first of all. And so users aren't going to get prompted constantly when they get to sites. It needs to be based on some trigger. A lot of that is user-based, the user clicking on something, engaging with something, that sort of thing. But there's some other heuristics that you can take a look at the documentation. I can send it to you if you want the specific links, and it kind of steps through that. But this is something that we're in the process of developing and starting to roll out, and so there's probably going to be a number of iterations on how this ultimately works as well.
All right, so there's a lot of research opportunity in connecting what we're going to be talking about in Group 4, which is UX for opt-out and consent, to things like Storage Access API and permissions for all the privacy tooling in order to give the users the best possible experience. And when I say the best possible experience, I don't just mean the experience that gives you the fewest annoying dialog boxes. I mean the experience that best reflects that user's actual preferences in how their data is used. So, any other questions about privacy protection? Yes.
In the macro sense, what is the meaning, breadth, duration of consent? Because I mean, like, when have I given consent? How broadly and for how long does that consent last?
Sean, do you want to take that one?
I can.
Okay.
So the consent lasts as long as the user grants it in the Global Consent Manager framework. So I can actually go in and change the consent that I grant. And it doesn't prompt you 5 trips to the site. Is that what we settled on?
Yeah.
So you're blocking by default. And then if you show some loyalty by visiting 5 times, you're asked if you want to share data. And then you can choose to share data, but that's fairly easily and visibly revocable at any time if
The browser itself is tracking.
this is right now it's a plugin. I think there's some discussion of making it part of the browser ultimately, but right now it's a plugin.
It's a plugin that's in the process of right now it's a browser extension that's in the process of being leveled up to one of those studies that gets tested out on Firefox users. So Global Consent Manager is an experiment to figure out how can giving users a different consent experience affect engagement with the site. And the result that we came up with, giving users a news task and asking them to navigate to 3 or more news sites and try it out both with the original consent experience and with Global Consent Manager, this 5 times detecting tool. We got a significantly higher number of minutes of engagement with those news sites, giving them the Global Consent Manager experience versus the original experience. And this is pretty. This was actually a pretty expected result, because if you go to LinkedIn and you first join the site, they prompt you for just enough information to get logged back in. If you continue to use the site, then they'll keep prompting you to fill out your profile, add where you went to school, add your job, share more and more info. But LinkedIn doesn't block you out of the site until you submit all the forms. Compare that to how news sites handled GDPR consent in their first iteration, which is basically, before you read one word of the story, give a bunch of companies that you've never heard of permission to use all your data for all reasons for all time. Terrible experience, not as good engagement as the progressive incremental experience that you can get with Global Consent Manager. So it really helps not just abstract privacy language, but actual time on site. Oh yeah, Brendan.
You expressed a little bit of concern about client-side heuristics, like a client tracking what sites you're visiting and frequency. The trend right now at the technology level seems to be that client-side heuristics for privacy and UX are okay to do. So Safari's ITP 2.0 and ITP 1.0 also do discovery of tracking domains through client-side heuristics, which is dependent on tracking what sites people visit and their interactions. So that there is strong precedent that is a privacy compliant way of doing things, as long as you don't send that data elsewhere.
Thank you. Question in the back?
How did there's a bunch of different double keying implementations and cookie blocking implementations. How did you guys land on third party, like say Google and Facebook, when granted consent in the first party context? So I visit google.com, I allow, and then I go to New York Times and Google is present. Is that allow or deny?
I'm going to guess denied, right, Peter?
Yeah, it would be denied in that sort of scenario. Oh, sure. You want to?
So there's a number of third parties that have both the first party and third party present. So Google is an example, right? And so if I visit google.com to do a search and permit a cookie to be set, and then I later visit the New York Times and there's a third party Google tracking widget, pixel, the question is whether that third-party tracking pixel would be allowed to set and read a cookie. And I think the clarification.
Yeah, so, and for Firefox, I don't know what the current is on Safari, but on Firefox, it would be denied in that case. I believe the original implementation of ITP from Safari, and they may have changed this, was to allow in that scenario. And we were concerned that would just basically give further dominance to Google's and Facebook's of the world. And so our position is it would be denied in that case. It is, and it's also closer to a user expectation. Just because a user did a Google search does not imply that they expect that Google should be allowed to track them on a random third-party site.
And then another super nerdy follow-up, but allow Google on New York Times. Does that also allow Google with the same cookie on WAPO, Washington Post, or are they separate cookies, or are they separate consents?
So the question is it on a site-by-site basis? It is on a site-by-site basis. So yeah, users would have to agree to that on the one site and then separately on the other site.
And that would be the same cookie at that point then?
I don't know. I don't know the specifics on the technical implementation there, so I'd have to check on that.
Yeah. So the question is whether cross-site tracking is allowed, and under what considerations is cross-site tracking?
Right.
So we don't know. Okay.
Yeah.
It's the same cookie for the third party, but the different cookie for the first party.
Sure.
Yeah.
Sure. So cross-site tracking would be allowed, but as long as you permit it on a site-by-site basis.
That's right. Yes.
And a lot of this stuff is subject to research and changes, tweaks, and improvements based on, one, what will give us better user experience, two, what will keep users engaged with the browser, and then three, workarounds for people who have figured out how to get something that's against Mozilla principles, but happens to slip by the current implementation. So it's I think, important to understand both the principles and the implementation, because just going for the workarounds is going to be a very short-term investment. The sooner people figure out, or the Firefox developers will see workarounds and make them stop working. Other questions? Oh, yeah.
And I want to be clear that Mozilla Firefox, we invite participation here in terms of feedback. We are cognizant that we are introducing a change that's going to affect the ecosystem, and we are very interested in knowing, are there some legitimate use cases that we're breaking, that we are not aware of, that we need to put something in place to enable. And so we are, we use Bugzilla for all of our tracking of all the work we're doing. We invite people to file bugs, describe the use cases that if you test with our Firefox Nightly or beta products, if you see things that from your own business that are not working properly, that you expect to in such a scenario based on the policies, feel free to engage. File bugs. That's where we can communicate with you and talk about our policies and how it applies, and then address specific issues if there exist at all. So we spent many months going through to make sure we don't break social logins and things like that for people. We spend a lot of time on this rather than just rolling it out tomorrow. So we're spending quite a bit of time. So feel free to engage.
Yeah, and Bugzilla is kind of a big, hairy form with a bunch of questions on it. So if you run into something that breaks, then you can just call me and we'll share screen, and I can fill out the complicated Bugzilla form for you. I'll tag you on it so that you can follow it, but please try Nightly, because that's where the future stuff is going to be. And if something behaves in a way that you don't expect, then let us know. Thank you.
Sorry. One question? Yeah. And then we're going to go to...
Can first parties get around the blocking of third-party cookies by just passing the data on to them?
As in doing server-to-server data exchange?
Yeah. So if a first party wants to be able to use their ad tech that requires the third-party cookies, can they just pass information on to them? Or is this not a sensible question?
Well, if it's happening server to server between that first-party publisher site and some third party somewhere, then the browser can't really see it.
Yeah, I know.
So.
My concern is that if you turn off third-party cookies, that they'll get around it some other way.
Yeah, so certainly there's a lot of ways to work around protections in general. From our perspective on the Firefox side, we will actually soon be publishing a set of policies that actually define what is sort of an acceptable form of tracking-based mechanisms, cookies and that sort of thing, and what is unacceptable. And we go into detail on the sort of things like link decoration and things like that. And and we give examples of, here's legitimate use and here's an illegitimate use. And an example of an illegitimate use from our perspective, from a user perspective, representing the user, would be passing information in the URL that would uniquely identify a user. That, from a policy standpoint, that's a sort of a no-go. Now, the second part, that's a policy. The second part is, does the browser or does the technology enforce said policies? And there's certain areas we do enforce today or will enforce soon. There's other areas that may be precluded from a policy standpoint that we don't yet enforce, but we may in the future. And so that's going to protect against some workarounds.
Just a common one currently to address Safari, as many know, is to force the publisher or the website to load JavaScript on a first-party basis that reads a first-party cookie. So if I want to use X Analytics company, rather than using them as a third-party widget, I host this JavaScript as a first-party, and that JavaScript sends it to a third-party. So it basically manipulates a first-party cookie, and that's a common practice currently to deal with Safari. And so we'll probably see that trend in the arms race. That's why you want, in my opinion, you want a technical solution and a policy solution simultaneously.
All right, thanks, Don. The conversation was starting to get super technical, and I want to point out that in the group on UX opt-out and consent is a good place for a super technical conversation about that. With the time we have before lunch, one of the reasons we're doing the tech conversation before lunch is because we know that you're alert. So we know this tech conversation is always a little bit. But what I wanted to ask Bill to talk a little bit about the federated authenticated user, because that's a key part of what Itega hopes to have developed. And I know a lot of people had a lot of questions about it. So Bill hasn't prepared, but I know he always knows how to talk about it.
Okay. Well, I think the best thing to do is talk about it by means of a couple of examples. I think I have had an affiliation with UMass for many years, an academic affiliation, so I have a login at UMass. And I've also done a fair amount of work at the University of Missouri, and so I would go back and forth. And so there's a service called EduRoam, which Scott Bradner, who you heard mentioned earlier, helped design, such that if I arrive on the University of Missouri campus and I want to log into the network at the University of Missouri, there's a thing there, and I'm not a technologist, and there are technologists in the room who probably know much better than I do how this works. But the point is that I arrive at Missouri, there are servers at Missouri that say, that I log in with my UMass credential, and it checks back to a machine at UMass and says, user WP Densmore at umass.edu is attempting to use the server at Mizzou to access the internet there. Are they an authorized user? And UMass checks and sees that I have a valid email account there, and I'm a real person at UMass, and it answers yes. So I get access. So that's a very, very simple implementation of the idea of a federated authentication network. But that particular one doesn't do really much of anything other than just pass a bit that says, yes, Bill is authorized. It doesn't pass any information about me. The idea that we've been cooking here is the idea that there would be a service where the authentication server might be a newspaper or might be a federation of newspapers like a local media consortium, and it would know that I'm a valid user within that context. And if I show up at another service that is maybe also within the local media consortium or within some affiliated entity like another newspaper, it has a way of checking through the magic of some technology similar to this with my home base and say, is this a valid user? But the wrinkle that we're talking about trying to add is, yes, you're an authentic. This is an authentic user, and by the way, here's a little bit of information about this user that the user has previously consented to pass. That's a little bit kind of what Global Consent Manager is trying to do in the browser in the advertising context. So I'm going to stop there because I'm anything more, I'm going to feel like I'm a non-techie talking about super techie stuff. But let me say, does anybody have questions about the idea, the premise of what we're trying to enable? And also, are any of the techies in the room able to better fill in the blanks here about how it might work?
Questions or comments or added?
I have a question on Ashkan's behalf, kind of. How, in the system that we're envisioning, how is a person anonymous? How do we sort of maintain that ability? I mean, it's a pretty crucial question that I don't have an answer to, and I don't know if others do.
I'm going to actually proxy that question to Rick Lerner because he's done a lot of thinking about that, about ways that could work, and there may be other people in the room who have ideas too.
So the way we've thought about it is that the consumer is not anonymous to their service provider. So the newspaper that they have their account at, or in the case of Bill's example, UMass knows who Bill is. But you can but you've chosen your trusted service provider that you are willing to be identified with. The anonymous aspect comes in your ability to access lots of other things where they know in general terms that you're maybe a real person, or B, that you're part of this network, but they don't know who you are. And the system protects your identity, assuming that one of the pieces of data you've agreed to share is not like your email address or your name, but it supports anonymity in the sense that you can access sites in a authenticated manner, but it doesn't know who you are. And whether it knows who you are the next time, or whether it knows the second time you go there that you're the same person that was there before, is configurable both in whether they can make that connection at all, or if they can make that connection for some period of time, but then that connection goes away.
One other quick follow-up. Quick over to Dan, but one other quick follow-up thought is you might be asking, well, so what's the point of this? And the point of this is, in the ad context, is to figure out a mechanism where advertisers can get the information they need to decision a useful ad to show you without knowing who you are or being able to track you in any other context. It also potentially creates the opportunity for what I like to call a fast pass for news, where you can go to multiple sites within this affiliation network and essentially be logged in. And in a sense, you might be thinking, well, that's a little bit like Facebook Connect, and it is a little bit like Facebook Connect, but the difference is that in the Facebook Connect environment or a Google Accounts environment, there's one entity that controls all of those names and all of that access. Whereas what we're talking about is a system in which there can be a plurality of identity service providers from whom you can choose how to manage your identity. Or in the case of Global Consent Manager, it's the browser, it's your browser that's acting as your identity service provider, if you will.
Mike?
So I assume you're doing this through hashing on an anonymous, right? Once the account's set up with the trusted provider, anybody else sees just like a hash as an ID or something? Okay, and then following up on that question, I mean, I like that model. I like the idea of that. I think it's the right thing to do in terms of maintaining an anonymous identity throughout other providers, giving information that's valuable to others. And then I don't know if you were talking about it as well, but I thought that was interesting if you can also tie content to it. So it's like Flipboard, basically. But for LMC, you can share content as well that's directed to users based on their interest and affinity.
the the token that gets sent to the remote sites that you may be accessing could allow those sites to access data in a data exchange in much the same way that advertisers can. So if the site wanted to be able to know that this was someone who was interested in pregnancy information, and you, the consumer, said, yeah, that's okay to look up some of my interests, it could do that without exposing your identity in the same way that the advertisers would be able to do so.
So when we're talking about, this morning I was talking about the tech stack. So there's promoting and supporting the browsers that will have a kind of consent management regime. There's creating this federated authenticated identity. There's the user exchange that that like Dave was talking about with Meridio, and then there may or may not, we need to find a way to get ad servers to protect privacy. So those are the four elements of the tech. Does anyone have? And we're going to talk more about some of the ways that those are connected and who might and how they might be built and the interplay between some of them in group 3 if we get a mass of people for that. Does anybody have any questions right now? I don't know if around what other tech we might need or have comments or suggestions or concerns, blah, blah, blah. Yes, good.
Hey, so I'm sorry, I just need to dumb down a little bit to make sure I understand it. So I go to the Miami Herald and I log in, and based on whatever they tell me, I agree to something. And then when I show up at the Anchorage Daily News, I am authenticated as user XYZ, but it's not tied to my real name identity. It's pseudonymous, right? And then Anchorage Daily News also would have the ability to look up pseudonymous user XYZ in some sort of database. I don't quite understand. But let's say it's a big blob, and they can look. Oh, XYZ. We know he reads sports scores, and we have other data sources, and we'll talk about that too. And so this allows us to serve or to identify him as with these interests, and we can tailorize content and ads based on that. Is that the basic model? Okay, it's helpful.
Yeah, that it might know because of a globally unique ID for the Miami Herald that is not hashed. It might know that you came from the Miami Herald. It might be useful for them to know that. Right. It kind of has to know that in order to do the lookup. Now, there is one other approach that is possible here, and that is that instead of having to check back with the Miami Herald, you might check back with a central authentication service just merely to find out whether that user is authorized to be part of the network. And that the central service doesn't need to know that permanently. It might only need to know it on a session basis because the Miami Herald authorized the person.
I'm going to actually step in with a fast question, then I'm going to go to Fran and somebody else and Amy. What is the difference between the federated authentication service and a user data exchange?
Okay. Well, first of all, the term user data exchange is not an established term. It's just kind of a term we've been throwing around under the tent here. So we've applied it to the idea of a pool of information about users, which within the pool, within the manager of the pool, which we envision would be a nonprofit or some highly trusted entity, if not a nonprofit, that can be sorted into cohorts of like interests, and then that information then an advertiser who's getting ready to serve an ad, who knows that they have at the other end of their pipe, looking at that page, a user who's within this ecosystem, can say to the UDEX, look, I have a user, I'm trying to decide what ad to serve to them. Can you tell me anything about whether that user is likely to be interested in the following campaigns. And then the UDEX operator can look and see, only the UDEX operator knows that they would only know that that's a Miami Herald user, and that there are certainly attributes that have been shared by the Miami Herald with the user's permission. So the UDEX operator can say, look, the user you're about to serve an ad to is interested in hiking, and has said that they have an intention to buy a car. So, if that makes them an interesting target, serve an ad. If not, decline the bid. Does that answer your question?
Close.
I just want to verify when Justin said that if somebody goes from if he goes from Miami Herald to Anchorage, he's going to get authenticated by Miami Herald or this independent
Or
authentication.
The central service
yeah.
that's operating on behalf of the Miami Herald and all the other participants.
But Anchorage is only going to know about Justin's preferences or affinities if he said, yeah, it's okay for me to for that data to get shared.
Yes.
Correct?
But one possibility is that the authenticator, whether it's the Miami Herald or the Central Authentication Service, the rules may have said in advance that it has a certain amount of data about the user that can be automatically shared because the user is okayed it.
Okay.
In other words,
I just wanted to make that point because I know we have a lot of consumer advocates in the group that data is only being shared if it's been permissioned up front.
Correct. Yes. And that permissioning process is a dialogue on a first-party basis between the Miami Herald and the user. Yep.
I have a really short question, and some of it stems from the fact that I missed a lot of your introductions yesterday, so I apologize. But was anybody here involved with or have experience with the U.S. government's NSTIC program that's now not operational anymore, the IDESG program? Because I know there's a lot of expertise out there on how people were looking at developing privacy respective federated identity programs, and they had a lot of challenges, and figuring out the ways that they were addressing those might give you some solutions into areas where you're having problems. I stopped going to it when they went from NSTIC to IDESG, so my knowledge of the program kind of stops at a certain point. But I was just curious about if those solutions that they were looking at were being incorporated.
A lot of it. I don't have a lot of experience, as Bill said, but it's some. And I think that the system that we were trying to create there was much more complex than the one that the LMC has, because we're talking about different government sites that have different levels of security, different levels of privacy requirements, depending on, if we're talking about the Department of Justice or we're talking about something else, right, HHS. And the delivery of the response of the agencies was much more complex than this would be. In other words, this user is traveling through a pretty straightforward ecosystem, right? It's, at least from a technical standpoint, you're being authenticated, you go, you look, some data is being shared, you're served an ad. That's kind of it, right? The NSTIC was much more complicated as far as... Well, I think that's part of where it fell apart, right? I mean, if the government had decided to make it in government identity, in other words, when you're going to access services, you can do it in a seamless way across government agencies, I think that probably could have worked. And I know the Social Security Administration is still interested in trying to shift away from SSNs to do something similar. But putting it into the private industry, then that's basically when everything fell apart, because there are so many different approaches to doing something like this, and everybody had a different community of needs. People.
Yeah, as I saw it, part of the problem was there was no entity like ITEGA that was neither government nor private industry to try and shepherd the process that was trustworthy. And so you ended up with a lot of vendors competing over competing approaches to very complicated encryption strategies that you might need if you're dealing with money or dealing with Social Security accounts or Medicare accounts or health care, but which may not be necessary in this kind of implementation, at least early stage. Anybody else?
Yeah. So I feel like we've glossed over, or maybe I missed it, what's involved in the authentication. Is it just a matter of you visited this site, we know you, or is there an account? Have you thought more about what's involved in authentication?
I can just give you a personal reaction because I feel as if that's really part of the remit of what ITAGA has to think through in a multi-stakeholder process is, well, what data might we want to ask the user to offer it by default? If they want to be completely anonymous and private, then maybe all that gets offered is, yes, this is a valid user at the Miami Herald, end of story. Or it might be, this is a user at the Miami Herald who is willing to share the following interest attributes. But I can't answer that question because I think it's the marketplace will decide that. And individuals will decide what they want to share or not want to share.
I think your question might have been a little bit different about how does someone authenticate with the Miami Herald? Yeah. So the plan had always been that it's up to the Miami Herald to decide how they want to recognize that the person at the browser is who they say they are. And that could be through username and password, which is typically what people have been using up until now. The ITAGA may determine that that's not sufficient and that there are two-factor authentication systems that they want to require that in order to authenticate in the network, you have to have done that. But the system itself doesn't demand one type of authentication over another as far as entering into the system. One thing that we did always envision was that the Miami Herald might be willing to have someone authenticate anonymously in that they're not providing personal identifiable information, but you could create an account with a random number for a username and a random password, and that may be all they'll ever ask. Over time, it becomes less anonymous, so it's not clear what the value of that is. But in any event, the bottom line is it's up to each of the registrars to determine how they want to authenticate their individuals, aside from policy that the network decides they want to demand of the individual registrars. Does that answer your question? Great.
Anybody else?
I'm not sure if that question was also kind of addressing some fraud concerns, because if it is, I think there's things we could do on the session side, session management, looking at analytics of activity that's happening once people are authenticated. You can start doing some analytics on that to see how many sessions they've opened, how many different sites they've gone to. So there's ways to combat that once you know an identity at least.
Okay, so now in the last hour, we've got a kind of an overview of some of the tech that we're talking about. And this morning we talked about privacy. Michelle, what's going to happen in the afternoon?
Well, Joellen, we're going to have lunch at 12:30. It was very smooth. So we're going to have lunch, and feel free to mill around. We're going to have a discussion, previewing a talk later that gets into detail about what's happening in the regulatory world. So what's going on in DC and the EU and California. Then we'll have a group discussion that's sort of twofold. The main subject is Google and Facebook. How do we play with the big platforms because they're not going away. And I think there were some ideas floating around earlier today that might give us guidance on how to do some kind of partnerships. How do we allow LMC to maintain that relationship that they and their publishers have with Google, for example, and now Facebook, and without being antagonistic to them, is sort of breaking down those relationships to see what's there, to see if it's possible to have aligned incentives for both big platforms and the smaller publishers. And then maybe also talking a little bit about what's needed to align those incentives. So we might say a marketing campaign is really necessary to make sure that Google is up against the wall about antitrust stuff, and we will say, hey, we're going to help take that pressure off for you, Google. That's kind of a crazy approach maybe, but that's sort of what we're talking about. There are also publishers in this room, I hope, people sort of representing advertisers. We also have the advocates. Is there anything that's going to make you not support something like this? And I know we talked about that a little bit yesterday, but maybe more specifically, what would be needed to get your industry or your support behind something like this? Just want to raise those up. Then we'll go into the small issue groups, and those are the groups. So start thinking about which group you want to be a part of, because you'll self-assign yourself and go. And what you'll be doing there is figuring out what is our group going to do. It doesn't have to be right, war, and peace, but it needs to be something helpful. How can we add our perspective to this conversation now? Because this is getting built, right, in the next year or two. So this is the time to add your perspective, and through these groups is how we're going to hear that from you. So important to kind of lay the land and figure out what your deliverables are. And then after that, we'll have a discussion about the legal horizon, so more in depth about what's going on in regulation and law related to all of this. And we'll wrap up around 3:45 or 4, so you can get out a little bit early. That's all. There's no keg. Sorry. I'm sure if you wandered around NYU here, you could find some alcohol. I know, I'm sorry, Chris. But we do have
Okay.
I think we should stand in the center.
Yeah, walk around, pace. Yeah, I don't know. Full. Yeah. So CCPA, as we know, does 4 things basically. The story of CCPA. I'll give the 1-minute version of the story of CCPA. Again, Ashkan's not here, who can correct me, or can't correct me, I guess. So I'm happy to do it instead. Alistair McTaggart, Central California real estate developer, Northern California, got ginned up about privacy, and way policy gets made in California is rich people sponsor ballot initiatives, and a lot of privacy policy gets driven that way. He hired like a law firm in California to kind of draft a privacy bill of rights, and got enough money behind it. Cambridge Analytica happened. Suddenly, there's a lot more popular interest in privacy, and so suddenly it looked like in the election it might pass. Apparently, California has a bi-yearly tradition of legislature trying to throw their body in front of ballot initiatives in order to forestall that imperfect policy-making process, by which they agree to enact similar protections in law, but which can be more easily amended and aren't maybe thought through a little more. From the downside, from privacy perspective, they can also be subsequently watered down. So anyway, they went through a very quick process over like 2 or 3 weeks, wrote a bill that was similar to the initiative but weaker in some ways, more implementable in some ways too. Passed it. Alistair dropped his ballot initiative. They did a series of technical fixes last summer, and then this year there's going to be several more rounds, prospectively, of changes. Designed, 1, to make it more clear, because it's still very badly written and horribly organized, and 2, maybe to change some of the protections. Advocates would like some things to be stronger, around enforcement, certainly, around portability, lots of other things. Chamber of Commerce has like a 40-point letter of the things they want weakened. So we'll see what happens over the course of the next year or so. The Attorney General of California is empowered, and she's required to issue clarifying regulations on like 5 or 6 things. They're going to be doing that over the course of this year. There are a series of workshops in California over the next month or so for them to seek input on that. And then the law will go into effect, I think, in 2020. The law does 4 things. 1, mandates a little bit more transparency. Right now, California has a law saying you have to have a privacy policy, but it doesn't really say what you have to have in it. And so privacy policies are kind of like Google's. It's like we collect data and do stuff. And so they're trying to get them to kind of tease that out a little bit more. There's a right to access your information. Subject to a verifiable request, unclear what that means, that you can access the data that a company has about you. There's a right to delete the data. You can get rid of it, and again, there's lots of exceptions. If I owe you $20, I can't make you delete that. So a series of operational exceptions, but broadly, if you're keeping data around, certainly for marketing, you should be required to get rid of it if I ask. And then there's an opt-out, an opt-out of data sharing. And so if you are a grocery store, that's a bad example because that's already illegal in California. If you're an electronics store and you sell to Axiom that this email address or this other identifier is interested in electronics, I can go to a service and opt out of that sale, or opt out of all things prospectively from then on. And you're supposed to be able to empower people to opt out on your behalf. And so you can have opt-out agents. And again, that ecosystem doesn't exist yet, but there's a thought that maybe it will develop over time. So those are and again, how it means in the ad tech space is unclear. The definition of sell is super broad to include permission all sharing, but sharing with service providers is accepted, and there's other operational exceptions in there. So it's not entirely clear how all the elements, I think I said this yesterday, how it pertains to all the elements in the ad tech stack, and how you are going to convey that opt out anyway. That's something. So they're very clear that you need to say on your website, like in like 12-point font, like here's how you opt out. So they're very prescriptive as far as how you make the information available about the opt out. I think it's a lot more uncertainty about what the opt-out will mean in practice. Like I said, I've talked to a bunch of different folks about it, and everyone has a very different opinion. Alistair McTaggart thinks it's super broad and will stop all ad tech in its place, in its tracks. I think some of the folks in the industry don't take that as expansive a view. The AG may issue regs around it. Again, we'll see how aggressive the California AG is on enforcement. I mean, we're seeing regulators in general be a lot more aggressive on enforcement. So I don't know, but it's a big stick. The penalties are substantial, but still, I mean, a lot will be in motion in 2019. So again, we're not entirely clear what the stakes are. Any questions about CCPA? Sure. I think IP address is included in personal information. Oh, sorry. Oh, yeah, that's a good question. I'm not sure how much I've thought about that. It applies to anyone who, yeah, it protects all California residents, but I guess, you know, if you're like, you know, cell phone company, if you register, if you have physical email, a physical address, then you're covered. But yeah, I don't know. Does anyone else know the answer to these questions? Okay. I've not thought out all these scenarios. I've thought about them in government surveillance. And there's like a lot of literature on it. I'm not sure. Someone may have thought a lot about this for CCPA, but I'm not that person. And you want to talk about like federal? Okay, go, Don. Yeah, so I think that's one of the so by service provider you mean like my opt-out like buddy, or do you mean like the exception for a service provider is accepted from the opt-out?
As in, if a local news site wanted to run an opt-out service for its loyal subscribers.
Okay. Yeah, right. So that's definitely envisioned in there. I think, and it's not super well fleshed out. You are allowed to appoint someone. Someone can opt out. So that can happen. The opt-out is not authenticated like the access requirements are. Right. So in order to access all someone's data, I need to prove I'm Justin. Or I'm associated with this email address. That's not really the case for the opt-out. So there's less rigor around it. This is something that a lot of people freaked out around. Do not track. Like everyone complained. The ad tech companies complained. It's not authenticated. We don't really know if someone's really opting out. Microsoft is turning on the do not track signal. AVG's inserting it into all the traffic they're seeing. So again, and there will be efforts in CCPA to put the authentication back into, or not back, it was never in it, but into the opt-out, which would make the local TV station's job a lot harder, right? They would need to demonstrate in some way that they have Joe Jerome's stamp, seal, wax, imprimatur. I mean, so yeah, that's not in the law right now, so they're not working that out.
Also, to add on to Justin's great background, Kashmir Hill wrote a really good story on the development of the CCPA, which includes some really troubling aspects of how it got developed that I would highly recommend you read through if you are interested in that. So there are two answers to this question. One is the CCPA is not explicit about its geographic scope. It requires that an entity subject to the law does business in California, but that doesn't seem to be limited to physical presence. So anybody who offers goods or services to persons or entities in California and purposefully drives benefit from activities in California probably falls under. And then the CCPA sets out a number of threshold criteria for what type of entity constitutes a covered business. It has to operate for profit, collect California consumer personal information. To me, that is a California resident, just by broad scope of how that reads. Determines the purposes and meanings of processing that information, and meets one of the following criteria: has an annual gross revenue exceeding 25 million, annually buys or sells personal information of 50,000 or more California consumers, households, or devices, or derives more than 50% of its annual revenue from selling California consumers' personal information. So those are both the jurisdiction and entity subject.
Other questions? I mean, I think still some of the edge cases, like when a California resident is traveling, right, or yeah, I think they're still to be determined, and yeah, and that may be an area where the Attorney General offers some guidance. I don't remember that was one of the areas they were specifically tasked to provide guidance. It's not in effect yet. Yeah, I feel like the fines are $250 per violation, $750 if intentional. Sounds like ballpark, right? But I mean, like, but I mean, but it also means like there's like how many people are in California? Like 30 million? I don't know. I mean, like, but the bunch. $250. But still, but I mean, it's not gonna be per. It's not gonna be per bug on your website. It's gonna be per person that affects on that bug on the website. Probably, right? I mean, it's not entirely clear, but so it could be. I mean, it could get into the billions very quickly. Obviously, that's still constrained by fairness law, right? Like the Eighth Amendment.
I mean, I think part of the problem with that is really knowing the identity. I mean, how could they enforce something if you can't really truly say that's a California citizen? Because I could be visiting, and I could be on my mobile phone in California at the time with the IP address of California. So what's the proof to show that that company was not doing the right thing?
Testify, he said we're going to apply this to everybody. I think that will be the practical impact of California as well. The elements that are specific to the user, access provisions, et cetera, will just be something that people start offering just because of exactly what you're describing. How do you determine who a person is? And there's a lot of ways to fake that.
Yeah, and I'll add, I mean, this is not a new issue, right? I mean, like, states have been enforcing consumer protection laws online, since then. I mean, I worked in the New York Attorney General's office in the Internet Bureau, and we encountered this issue. Like, some company had a data breach or somebody did something stupid, it's a privacy violation. And we knew it affected a bunch of New Yorkers, right? But, I mean, the thing is, like, in practice, like, 90% of these cases are negotiated settlements, and so you don't need to necessarily prove in a court of law how many people were affected. Often they're multi-state, and again, when we see other states that adopt CCPA-type laws, maybe we'll see that sort of thing as well. But I mean, that's another thing that's worth pointing out is that, I mean, there are a bunch of other states that are now excited about CCPA, and so we've heard from states that want to kind of just do cut and paste CCPA, very similar to it. We've also heard from states who want to do something fairly differently. And again, this is probably not optimal policymaking to have each state regulating the internet separately, and you need to have like a lot of like if-thens based on IP addresses that may change all the time. At some point, this may violate the Commerce Clause, like the Constitution has a doctrine that states can't set laws that are just wildly out of sync with what other states do, to the extent that it interferes with interstate commerce. And so I think like the example I learned in law school were like railroad tracks. Like every state in the country had like the same railroad gauge. Then Michigan mandated to be like 6 inches shorter, just to probably benefit like their local company. And the Supreme Court said that no, that violates the Commerce Clause. Michigan's just messing with commerce. I'm sure there will be challenges. I think CCPA has already been challenged in court. I'm sure this is one doctrine. I'm sure Axiom's First Amendment rights are another doctrine it's been under. It's probably a bunch of other ones as well. So there will be constitutional challenges to CCPA. And again, like the fairly conservative judiciary, Brett Kavanaugh has spoken at length about state regulation, companies' First Amendment rights. So it could be, we could have all this fun for nothing. Yeah, but again, there's been discussion about federal legislation. Apparently, Marco Rubio announced privacy legislation he was releasing today at some point. Yeah, the only thing I know about it is that it has strong preemption, which for like a lot of folks is like the driving force behind what they want to see in a federal bill. But we'll see. There's been bills there's probably like 5 bills that have been released out there. More, okay, already. And then there's also like it's like an iceberg, right? There's like so many been released, and then like every other member has one as well, and so we're gonna see the iceberg come up. Again, it's divided Congress. I mean, CCPA and GDPR and companies wanting something are strong pushes for federal legislation. At the end of the day, it's still like the federal government, which is not great at doing stuff. And they only have so much floor time. They want to confirm a bunch of judges, and I'm personally not optimistic that we're going to see legislation in 2019 before the presidential election, but who knows? I mean, privacy legislation has moved super quickly in the past before, so it's definitely possible. But I feel like the House Dems and the Senate Dems, the Blumenthal's, Markeys of the world, are really in a different place than the Marco Rubios of the world. Whether they can find common ground fast enough, I'm personally skeptical about. But who knows? But I mean, like in general, there is, in addition to the privacy stuff, there's a lot of more concern around competition in DC, but also concerns around big tech companies. And so I'm thinking through this initiative through the lens in which DC is seeing stuff these days. Yes, there's a lot of interest in stamping down the power of the Facebook and Googles of the world, but there's also a lot of inherent skepticism about surveillance capitalism in general. And so I think there will be, you've heard from some of the privacy advocates in this room, surveillance capitalism by another name. Yeah, we solved the Facebook Google problem, but this may be something that folks don't want to opt into, or folks feel uncomfortable with, or folks feel is coercive, or folks fear is unfair to certain communities. Is still, I think, a something that you'll need to grapple with. But again, it really depends on what the user experience is. It really depends on the terms. It depends on how invasive, the data you're getting is, which I think are still things that y'all are working out.
Calling on some of the other privacy advocates, or whoever has some knowledge about what's going on in Europe, and even maybe CDT's baseline privacy bill. Give us like an overview.
I'll let you give the overview of the CDT bill.
I don't know how much people are monitoring stuff in Europe. I'll just comment. The thing that I think is relevant, at least in terms of Europe, is a recent decision by the French Data Protection Authority, the CNIL, which looked at basically an implementation of the IAB TFC by a TCM. My bad. I'm sorry. There's too many acronyms and I'm messing them all up. You're probably following the Vectuary case, right? Oh. I don't work there anymore. In any event, I think I'd like to reiterate what Justin was saying about how, in the afternoon, like really UX is incredibly important here, and what that case sort of stands for. If you're a privacy advocate, you're going to say that this is suggesting that everything that the IAB is doing and self-regulation is in violation of the GDPR. If you're an industry type, you'll say, no, the way the company deployed this implementation was inadequate. I think there's a lot of wiggle room in the decision. It's also in French, and I don't natively speak French, so who knows what it actually says. But it really sort of goes to European DPAs being very concerned about what options are being presented to users and how they're being communicated. I think there's an inherent tension among privacy advocates and privacy laws to have this clear and complete and informed consent. I don't know how you do that. I don't know how you provide informed consent that's also clear and easy for people to read. But the Europeans are trying. And the Vectuary case sort of goes to an ad tech company that was not providing consent to a manner that was satisfactory to a European DPA. So we'll see what they do as follow-up to that. But I think that sort of is going to, once again, emphasize the importance of UX and design and interface and how you're obtaining permissions. I mean, that's sort of at the crux of a lot of the actions that Max Schrems has brought against Google and Facebook. what is it? Is it the Norwegian, Finnish consumer group? Well, Privacy International is the one that filed complaints against a number of data brokers and ad tech companies, saying that they weren't obtaining correct consent and they were using dark patterns and all of this stuff. So I think that is really generating a lot of interest. I guess I'll be more optimistic than Justin and say that with respect to a federal privacy law, it's probably accurate to say that nothing will happen, but that's what you say until something happens, and I think that's what'll happen. I think the lesson I've taken away from DC is there's a 20% likelihood that Congress is going to pass anything, right? Like healthcare reform took 40 years. Okay, so that's a less than 50% chance that anything's ever going to get done. But then something does get done, and you have to readjust to this. It seems like that there's sort of this privacy moment right here, and there's a lot of interesting ideas. What could actually get passed at the end of the day could actually end up being really bad for any number of people, but there's just such a multitude of different things going on right now. NIST is doing a privacy risk framework that I think will probably drive a lot of industry self-regulatory efforts. The Trump administration claims it's going to get involved. The Federal Trade Commission if it ever gets opened again, is holding a bunch of privacy hearings this spring that are bigger than its past sort of workshops, so something will come of that. And there's a lot of bills, and as Michelle mentioned, my organization, CDT, put out a discussion draft of things we'd like to talk about in a piece of privacy legislation. What we have in ours is it's a mishmash of different proposals. We focus on things about and I think this is something we should also discuss this afternoon about things we were talking about uses, things you will and will not do. We were really concerned about things like sharing of biometric information, sharing of geolocation information, sharing of health information, however that's defined. These are things that I think directly impact advertisers, and they're things that have to be grappled with both because there's existing state laws that do it, and I assume you guys have seen the stories about all of the hubbub about geolocation information being bought and sold. These are all data categories that we operate under the assumption are sensitive data. I mean, that's existing. Like the Federal Trade Commission guidance, the self-regulatory guidance has its categories of information we construe as sensitive. And it's pretty clear that even though that's what we've all agreed to, that the rules of the road aren't being followed. So that's problematic. But I've been pontificating, so I want to pass it off to somebody else if somebody else wants to talk. Hey.
Just to add to why I think that we will see DC is not a monolith, but I think we will see movement over the next few years on data protection in Congress. And one of the reasons for that hasn't been touched on yet is the debates over the Privacy Shield. And I don't know how closely you all have been following that conversation, or if you know who Max Schrems is, because somebody last night did not, and I don't remember who you are, who didn't know who that was. So there was a arrangement, I get yelled at by our Brussels office. It's either an arrangement or an agreement. I think it's an arrangement between the EU and the United States that allows companies to hold EU data outside of the EU persons' data outside of the EU. Typically, they get permission to do this because the country they want to hold it in has a data protection law that the EU sees as adequate. However, because the U.S. does not have an umbrella data protection law, we had this arrangement called Safe Harbor, and if companies said that they complied with the different elements of Safe Harbor, they could bring information of EU persons into the U.S. A law student at the time named Max Schrems challenged that in European courts and had that arrangement knocked down. And the court said that essential equivalence was the standard. In order to hold information outside the EU, the protections had to be essentially equivalent to the protection they got in the EU. Oddly enough, the whole case started because of U.S. government surveillance. It was not a corporate case about corporate data use. It was about how the U.S. government was getting access to individual data from companies in the United States, specifically the NSA, coming out of all this stuff with Edward Snowden. And so we've been pretty critical because they replaced Safe Harbor with this thing called Privacy Shield, which garnered a lot of jokes about Agents of Privacy Shield and Marvel Universe jokes, if you're a nerd in that community. And they didn't change any of the surveillance authorities, so it was really hard to see how this arrangement could stand if Safe Harbor couldn't stand when nothing changed. Except we also really didn't put in place a data protection law, and so a lot of groups, mine included, really think the only way to provide certainty about how information can flow between these giant corporate economic entities is if the US puts in place a data protection framework that the EU says is essentially equivalent to what they have, because that will provide a lot of certainty. Privacy Shield itself is now under challenge. That case will go up, and we're watching that. But notably, so are, in alternative to complying with Privacy Shield, you can have what's called a model contract clause or a binding corporate rule, MCC or a BCR. Thanks, guys. And those have also been challenged to say that they are not essentially equivalent either. So if those fall, that case will go first, and Privacy Shield falls, companies will be in a really bad position. Because that includes employee data and user data, and nothing else that can move outside of the EU. So trying to get out ahead of that and those cases, and the fact that the court is potentially going to strike these instruments down, is a really good thing for industry, we think, and something that people might want to be thinking through.
In the midst of this, we just became a global company overnight, and we acquired a company in Canada, and they have employees all over the world. And that's what we were looking at. It was the EU Privacy Shield, but then we're finding that, well, that may not be something we can leverage. And then the binding corporate rules, the model contract clauses, same issue, that's being challenged. So I'm not asking for legal advice, but it's just maybe up from a group perspective. What do you guys think about? Does that mean we have to now create separate data centers everywhere for all that data? That's scary for me, because that's hard to scale your company and work. You know, they're developers, right? So they have to work very closely to each other across the world. It's very difficult. Well, that would be great, but if that worked, yeah. Right.
Yeah, I have a related question, which is, can you just move all the USA data over to Europe and comply?
If you held it all there, I believe so. I mean, not to provide legal advice.
No,
but I believe, like, yeah.
We don't have. You can do whatever you want with American data. Yes, you can send American data to China. No, absolutely, you can get around that. I mean, unless the only exception, there's no legal restriction on where you can send American data unless it's something by a contract. I mean, the only example I've sort of seen is I've been doing like work on scooters and smart city type stuff where cities contract to say that none of that, data can be held outside of the United States, because there's concerns actually that a lot of these scooter companies are Chinese companies, but that has nothing to do with advertising data.
Measures. And so I feel the reason I didn't want to say I'm offering legal advice is because I think there might be a challenge to be made that if you hold it in China, that maybe you're not providing reasonable security to the data that I'm just saying there's reasonable minds.
So this came up earlier in a conversation, so it might be worth just briefly touching on this idea of enforcement and follow through of the regulatory frameworks that we're under. So leaving Europe aside for a second, because it's slightly different in terms of their approach, but one, when you think about enforcement, outside of private plaintiffs, you have like AGs and the FTC. And the FTC has a privacy enforcement group that enforces unfair and deceptive trade practices, which primarily, outside of like special rules fall for privacy fall under companies lying about their practices, right? And that's the bulk of the FTC authority is essentially if a company makes promises about their privacy practices as to whether or not sharing data with certain individuals or allowing consumers to control their data, and then being deceitful about those practices. Unfairness is a different standard, and rarely do privacy cases fall purely on unfairness grounds, and that's for kind of some historical reasons. But that's the primary kind of enforcement authority on the federal level. People often think about the enforcement group outside of the privacy division that is responsible for enforcing cases that are essentially under the FTC jurisdiction. For folks that don't know, the FTC has this 2 strikes model where like the first time you screw up, you kind of go under a consent decree and maybe a small fine, and the second time there's actually additional fines usually, and rarely, but sometimes injunctions around certain business practices, etc. The group that does the second strike is actually a pretty small group of individuals that's responsible for overseeing every previous enforcement case that the FTC has. So they're cumulative. So as you get 3 or 4 new cases each year, that same group is responsible for overseeing those cases and all the ones prior. That same group of, I think it's like 15 or 20 individuals, is also responsible for overseeing obscure laws, like we were just talking about one, which is, those labels in your mattresses that say like, do not remove. The FTC oversees those rules as well. There's a bunch of obscure textile rules and other FCRA and other rules that the enforcement division is also responsible for. So they're incredibly overtasked with oversight. And so when they typically go after actors in this space, typically it's not like it's not a secret, but they either go after big actors that can change practices or small guys that are doing very bad things in order to set standards, right? They usually, actors that are trying to do well and screw up are rarely fall under kind of FTC enforcement, and often people doing the same thing over and over. So if one person gets caught for this one issue, they rarely go after another person for that same exact issue unless it's particularly problematic and harmful to consumers. Outside of that federal authority, you have AGs that are kind of stepping up, but they're also incredibly overtasked. And for example, the California AG is also a small group of individuals responsible for seeing all of the tech companies in California, along with all the other privacy cases, along with government privacy issues as well. And they, for example, aren't huge fans of new laws because that they're required to do rulemaking and enforcement of these new authorities. So the enforcement landscape's kind of limited, unfortunately, in the US. So even if you have strong rules, you rarely have strong, precise enforcement. It's usually selective enforcement to set baseline practices. In Europe, it's a little bit different. I think the DPAs in the individual states are much more active in enforcement, right? And even around GDPR, it's really up to the DPAs and groups and collections of DPAs to bring forth actions. And Amy and other experts can chime in here. And there we see a bit more, again, so GDPR, I think someone made the comment earlier about GDPR being incredibly vague. And I kind of think that's by design, right? I think part of the thing we're seeing with GDPR is that it allows for the DPAs to then bring cases with some potential weight and merit behind them against primarily big tech, right? And so again, except for the edge cases of actors being like the French DPA bringing cases against particularly bad practices that are common across the field and going after a small actor, where I think most companies of kind of your nature are not going to see the brunt of European DPAs focused on your practices, right? I'm not a lawyer and definitely want to trust my legal advice, but that's kind of the landscape of enforcement. So as we think about like the frameworks, while it's important to have everyone always punts the FTC will write rules and the FTC will enforce, I would not necessarily count on the FTC to follow through on much more than deceptive practices around clearly delineated rules.
So we're going to talk now about the the big platforms, since we haven't talked enough about them already, to get a sense of what you all think is possible in terms of when to bring Google and Facebook into this conversation. I'm sure they're already aware on some level of this project, but is there a way to partner with them? Is there a way to bring them into this project that in a way that's mutually beneficial? Thoughts?
I think it's a mistake to negotiate with them from this point. They take technological capability seriously. They take business connections seriously. They are happy to send out people to talk and have meetings and muffins and coffee and do nothing. But if you want to be taken seriously, there are capabilities that need to get built first. For now, there are some productive engagement opportunities with the employee associations that are concerned about those companies and values and impacts on democracy. But as far as talking to management, they will put you into the category of contacts for our dedicated manager of talking to unimportant people. Yeah, you have to have the capability.
I mean, Google knows that we're participating in this and we're doing this. I think that we have to put a lot more meat and strength on the bone before we invite them in the room, because either they'll ignore us or they'll try to co-opt the process. And that's just the truth. I would too if I were on the side of the table. I don't bother them. And then thirdly, is there activity going on with the FTC right now? I don't, they're trying to put all sorts of olive branches in front of us, both of them. I mean, D&I and what Facebook did yesterday is indicative of that. There's, there's altruistic means in it, but there's also, you got to look at it with, straight up and go, make you go, as some of the comedians would say. So I would definitely say that it's too early. I say when we have more meat on the bone and more strength is the time to invite them into the conversation. But the conversation can't be we're here to negotiate and see what you think. It really is, this is what we're doing, and do you want to participate with these terms? There's no way to negotiate down what we're trying to do here. And I don't want to negotiate it to a point where all we're making is a slight incremental gain as that pendulum swings, so that it looks like we did something and we really didn't do anything. It's just not in their best interest to be in this conversation.
My point was just going to be that we might want to turn off the live stream. Do you turn off the live stream just because we're using the terms Google and Facebook?
Yeah.
Yeah. Who votes to leave it on? Who votes to turn it off? Okay, so we'll leave it on for now. Okay.
All right, more conversation. Just want to bring that up over there.
I think Chris is exactly right. I think it's, I think if it comes down to identities, right? Right now they have identities. We don't. If we were able to go through and actually do something like this, create a trusted environment, we do have, I think, more trust than they have right now, obviously. I mean, we get the fake news media stuff sometimes coming from some people, but ultimately, I think we still have more trust than Facebook and Google does. If we actually start getting identities, then we have the meat on the bone, right? And what if we manage it? The way I look at it is, what if we manage the identity side and then connect it to their platforms? Now, that's a big stretch. I think they're going to say we already have identities. But if people trust us more and give more information willingly, freely, under consent, which a law may come later on, which enforces that consent, I think we're in a better position.
There have not been too many organizations that have been more critical of Google and Facebook. So from that perspective, I think Google and Facebook can actually serve a useful role, but you don't know what you want them to do yet. You got to build out what you're trying to accomplish. You got to build out what you're capable of doing in-house. And then I think you'll understand better where you need help and where. I mean, Google and Facebook they have a unique role in this ecosystem, unique set of data, unique sort of presence across the web, and so in some ways they can be helpful, but you don't know what you want from them yet, and so I wouldn't, it's too early. But at the same time, I wouldn't demonize them, shut them out completely.
So far, everybody's saying not yet. Anybody who says yes, we need to do it now.
Curious to hear your response to this. So the LMC members, LMC in general already has a partnership with Google. So how does that partnership change? I mean, do they just walk away from that, which is, revenue, represents revenue right now? Or how can that change or evolve in a way that works?
Well, I view this as we as publishers are just looking to try to get our house in order. That we are trying to develop a consumer-friendly privacy policy and take, I think, more prudent steps around protecting consumer privacy and consent, which is not, is something that we need to define. I agree with everybody in the room that we need to define that, and that that's not necessarily at odds with our relationship with the platforms. This is just something we as an industry are doing, and at the point in time, to everyone's point, at the point in time that we've defined what we want as an industry to do and how we want to manage our relationships with our audiences, then at that point, I agree. We say, here's what we're planning on doing. This is how it may affect how we partner with you going forward. But here are some ways that we could potentially work together for the benefit of the consumer. I quite frankly, yes, we do have partnerships with Facebook and Google at this point in time for various services of theirs, and I don't really see that being at odds with what we're trying to define and accomplish here.
And both Google and Facebook have capabilities to do GDPR compliance. So there's no consent mode for Google Tag Manager that's already in place. So I don't think it's realistic to say we're talking about a total cutover. It can be incremental.
This probably isn't relevant for local news, but it's interesting. The Australian Competition and Consumer Commission, the ACCC, has been involved in what they're calling a digital platforms inquiry that is specifically about the relationship between the platforms, Google and Facebook, with local news in Australia. They issued their report either late last year or late last year, December. And it might be an interesting read to see how a different jurisdiction is looking at these issues. The Digital Platforms Inquiry by the Australian Competition and Consumer Commission. There are some, from our perspective, very troubling human rights issues with what they're recommending, but I commend that as a resource for how people are looking at these issues.
And YouTube, and I sold a company to Google, so I love Google. Would never want to work there again, but I love it. I love them. Don't like Facebook. I have a lot of friends there. I'm not much of a user of Facebook. I think for me, with regards to user data, my operating assumption with regards to the Meridio project has been to focus exclusively on working with the publisher community, and once standards are set, then I'm interested in talking to Google and Facebook about whether or not it makes sense for them to participate in it. It was kind of like getting involved too early with them would have too much of a undue influence on the directionality of the entire initiative, which was an opposite strategy from the one that I took when we launched the AMP project, where I needed the weight of Google to establish a new global standard for content syndication. And I needed that kind of market power to actually, and just the carrot that is the carousel and search results to drive that new standard. Whereas here, I don't think that that's as necessary, and so I think that the influence that they would have. So I've actively tried to exclude Facebook in particular from meetings and around discussions with regards to user data, just because the politics of it are weird, and but once there is an industry standard of practice in terms of how we engage as an industry with the user, then I think it'd be time to bring them in. I just think that it's a matter of timing more than anything else. But I mean, that's just been, I don't know if that's the right approach or the wrong approach. It's just what I've done. So, yeah.
I'm sensing unanimity. Gary?
There's the context of working with Google and Facebook around a privacy framework, which is maybe one beast. But from the standpoint of the publishers, I mean, the thing that Google and Facebook are, if you dissect them, is a roadmap to what you need to do for success. Now, you may never be able to do each element, but the way they are able to get logins, get consent, get durable IDs, attach intent to durable IDs, to build lookalikes, to build act-alikes, to attach audiences to different advertiser needs, to provide or not provide what could be valuable data back to the advertisers. I mean, each one of those elements could be decomposed into a strategy that needs to be done by a publisher, and that's why they're kicking ass, is because they can close the loop, and sometimes they can kick ass without even closing the loop with their advertisers and round-tripping data, which means that as a publisher, as a differentiator, you could round-trip data from the advertisers that's their data back to them and help enrich their first-party data as well. So there's a roadmap within them, which is, you know, interesting to do a.
I completely agree with that. I mean, I think there's a lot of pages. I mean, for my startup, Distributed Media Lab, I mean, we're just taking pages out of YouTube and Facebook and Google's playbook, but establishing a business model that is designed for a decentralized architecture that publishers benefit from, taking pages out of all of the platform's playbook, but building the technologies to enable publishers to do the same sorts of things. You know, Google, over the years, you know, I think Don I think mentioned it, where Google's been really, really smart about how they have not allowed user data to leak. Except for there was, you know, in the early days, people got a little bit crazy at Google, started writing APIs for everything. And I don't know if LinkedIn would exist if it wasn't for an API that was publicly available to slurp up a lot of users for years and years and years. And then I was part of a project to try and clamp down on this kind of pantheon of APIs that Google engineers had built on the side over the years, and it was a disaster. But it was for all kinds of interesting services that Google had built into the infrastructure. On the business, Google has always known its business is advertising, which is a function of user data, so let's not leak it. You know, but they have allowed for other social platforms to emerge and scale because Google wasn't paying attention to how that was happening on Google's dime through some APIs that a bunch of engineers had built over the years and no one was policing. So it's really a kind of a mixed story. But unlike Facebook, which for a while there didn't know that they were an actual advertising business while they were an advertising business, and they thought, let's leak all this user data so that developers build on our platform, and in doing so, they were undermining their own economic position. And then they got told that that was a bad idea, and then they realized, oh yeah, that's not good for business either. I mean, so how the platforms have handled user data is definitely not a case study in consistent brilliance, but there are a lot of pages to take out of their playbook.
I was just going to say, I think that the different
the playbook that I want to operate on, at least, is maybe borrow some of the approach, some of the strategy, but in sort of going back to what Jeff was talking about, looking at data less as something that's filling a need for us and more as something that's offering us a chance to fill a need for them. So the idea that we're learning about you so we can actually give you value beyond content, right? So that we can be responsive to you beyond advertising. And I know advertising is necessary right now, but I think it's important to think a little bit beyond. So in other words, you know, Facebook didn't realize it was an advertising company. Maybe the publishers don't realize that they're actually service companies, right? That there's a bigger vision that I think would be helpful in guiding some of this work anyway. Anyone? Okay, it's cool. So let's shift into our small issue groups, if that's all right. And I'm going to write down a couple things on the whiteboard about the timing of all of this. And these are just guesses. It's really difficult to say when and how this is all going to roll out. But I'll give you the best guesses that we have about the timing. And so when you meet with your group, think about who is going to be sort of the point person. You know, because we really do need this to be carried through. Maybe you have a call once a month or less, whatever can work for people. Figure out what you want to accomplish in the group. The privacy policy people, I assume, would write a list of the most important things that should actually be in a policy, not just values. And also look at how different laws will come into play and how it should be, it should address those. And then what that deliverable will be. So deliverable is, here's a written recommendation for what we think should be in a privacy policy. And so just meet up with your group and we'll get that sorted out. You don't have to do any of that work today, just kind of talk about it and decide who you think should be the point person. And I'll give you the timeline so that will help a little bit. And then we'll talk about, I guess, a little bit early, which is nice. Maybe we can get out a little early. We'll have Elizabeth and Chris talking a little bit more in depth about GDPR and consent, and also some of the ideas in Congress that we haven't heard about, some of the specifics about the legislation.
So I would just like to say that we really value all the opinions that have been shared the last day and a half, and we really want and need your help in these small groups to try to help us actually, you know, build concrete deliverables. So hopefully someone will raise their hand to volunteer to lead each of those groups, because there will be some work, hopefully, that gets done after we leave this particular gathering, so that we can start making progress and actually have some concrete documents around how we're going to approach each of these areas. So your participation and volunteering to take on some of this work after this meeting would be very much appreciated.
So who would like to be in the privacy policy group? Joe?
Okay.
So why don't you guys meet over there since you're sort of over there?
Yeah, the privacy group can meet. Do you want to meet? Well, that's by the food.